Next is a descriptive business name, and this is quite difficult because anytime you have a name that describes your business, it is highly likely that there are other businesses out there in the world that have the same type of name describing their business. Now, if this is the case, you're going to need to show secondary meaning. That is, there is such a strong association between your specific business and that descriptive name that there is no potential for customer confusion. Anytime someone says that name, any customer would naturally think of your business rather than some other similar business of which your name might also be descriptive. So if you can achieve a demonstration of that secondary meaning, and that's going to take some research, it's going to take some proof. You're probably going to have to do a great deal of research and perhaps even get things such as affidavits and demonstrations of use of the term in other contexts by third parties unrelated and things like that to demonstrate secondary meaning. And then lastly is generic. And generic means that the name has become so commonly used and synonymous with a product or service that it is really not capable of protection. A generic name cannot be trademarked or protected under trademark law because, once again, it is so commonly used with a given product or service that it is not distinctive enough to identify your business. An example of names that have become distinctive, that have lost distinctive, that were distinctive at one time, might be something like refrigerator or Frigidaire or lipstick or Kleenex or Band-Aid, something of that nature where the name of the business and product has become synonymous with the product itself. So other makers, other brands might make a product and label it as such. One note to make, if you are going to file federally, and there are already within the United States businesses that do your type of business with an extremely similar name, you're going to have a very difficult time securing trademark rights over that name. You may be able to secure state law rights because that other business has not spread or begun to do business in your state and has not secured federal protection itself, but you will likely be prohibited from achieving federal protection, that is nationwide protection, and will have to depend upon state law in whatever state in which you are carrying on business and using that name to represent your business. In a nutshell, that is trademarking a business name.